You are now tuned into the Black Law Students Association of Canada's YouTube.
I would like to also point to Justice DeBella's articulation of step 2 in TAPO-TAT. She stated that it's no longer necessary for a group to show that a government's actions perpetuates prejudice or stereotype, only that it exacerbates their disadvantage. We submit that's exactly what the minister's failure does. Following step 1, the distinction here is that the minister has done nothing to ensure that Black Canadians, historically a vulnerable racial group, can benefit to the same extent as others when it comes to COVID-19 policies. Furthermore, the distinction in this case cannot be framed simply as those who are Black and not Black, or racialized and non-racialized. It cannot be framed in this way because to do so would undermine Section 15's goal of substantive equality. We want the minister to collect multiracial data and intersectional data. But to get to the point of the distinction in this case is that the minister is collecting data pertaining to age and gender that benefits some, but not race, to the detriment of racialized communities, especially Black Canadians. The distinction is based on race, and following step 2, the distinction is discriminatory because the government's policies are not protecting Black Canadians. Rather, they're exacerbating a community's disadvantage to the effects of COVID-19, which subjects them to a higher risk of infection. For example, health disparities during COVID-19 reflect 3 important patterns of inequity. First, Black Canadians being overrepresented in those diagnosed with cancer, kidney disease, HIV, AIDS, and diabetes are at increased risk for severe illness from COVID-19. Second, Black communities have a high likelihood of contracting the virus by living in urban areas. And lastly, Black Canadians are disproportionately working in high-risk environments, such as long-term care homes and hospitals. We can infer again from these statistics that Black Canadians are disproportionately unable to take the same precautions as other Canadians. The government has reported that the spread is caused from living conditions, workplaces, and access to health services. If this is the case, then addressing the spread requires the minister to acknowledge its particular impact on Black communities because they experience lower incomes, more precarious housing, increased exposure to environmental racism and pollution, reduced access to healthcare, underservice from the healthcare providers, and discrimination in the education system. It's a mouthful for me to say, so imagine experiencing this every day and contracting COVID-19 because of it. Black Canadians are not feeling protected by their government, and this can cause further mistrust in the system. To summarize, COVID-19 exacerbates existing inequalities, many of which the government did not help to cause, but these inequalities have major implications for the development of effective evidence-based responses. Without race-based data, the virus will continue to spread at disproportionate rates in Black communities. If there are no further questions for myself, I will conclude my submissions for today, and my co-counsel will continue on with the remainder.
I have no questions. I'm not hearing anything from my brethren, sistren, so to speak. So proceed.
Thank you for your submissions, Madam Burton or Miss Burton.
So it's Miss Grieve, is it?
Yes. Thank you, Justice Daguerre, Justice Peters, and Justice Slanky. My name is Sarah Grieve, and I will be continuing the arguments of Ms. Burton on behalf of the appellant, Mr. Jamal Williams. Now, I know Ms. Burton spoke to it, but I'll just say I've been experiencing a lot of lags this morning, so if you need me to repeat anything or if I cut out for a bit, I have no problem with repeating myself. Today, first, I will argue that the minister's failure to collect race-based data infringes on Section 7 because the minister's inability to issue public health strategies that respond to Black Canadians' experiences engages their rights to life and security of the person. Second, I will outline why the infringements on Sections 7 and 15, which Ms. Burton just spoke to, cannot be saved under Section 1. And finally, I will end with our theoretical argument on the government's obligation to provide positive rights. Now, Justices, the issue on appeal today is whether the Charter requires the Minister of Health to collect race-based data on the COVID-19 pandemic. But this case is also about whether the minister can continue to ignore the suffering of Black Canadians during a global pandemic. Jamal Williams is a Black man who fears contracting COVID-19. Mr. Williams fears for his loved ones that may contract COVID-19, suffer its consequences, or unfortunately die. The minister will try to justify her actions by saying that it's not the absence of race-based data that's the problem, and that it's not the minister that's the problem. The minister argues that it's COVID-19 that creates the risk. And the minister will argue that it's systemic racism in the healthcare system that impacts the lives and health of Black Canadians, not whether there's race-based data available. Instead, it's the entire system that's at fault, and so it's the entire system that needs to change. But the minister cannot undo systemic racism in healthcare in time to address the immediate needs of Black Canadians. Black Canadians cannot be ignored simply because the entire system is at fault. Now, Justices, under Section 7, we are asking this court to recognize that first, the failure to collect race-based data threatens the life and security of the person of Black Canadians because the minister is unable to allocate life-saving resources or services based on Black Canadians' experiences. Second, there is a sufficient causal connection because the minister's failure increases the risks associated with contracting COVID-19. And third, this is not in accordance with the principles of fundamental justice because it is arbitrary. There is no connection between not collecting race-based data and providing an effective evidence-based response. Now, the Supreme Court held in Chaouli that once Canada provides a service, it must comply with Section 7 rights. The minister has provided services in response to COVID-19, including financial support, research, and allocating resources such as personal protective equipment and ventilators. Without data, the minister cannot know the extent to which COVID-19 has impacted Black Canadians, and these services then cannot respond to Black Canadians' needs and experiences with the healthcare system. Now, you may be wondering, what are Black Canadians' particular experiences with the healthcare system? Well, the 2020 Black Experiences Healthcare Symposium report indicated that anti-Black racism has an ongoing negative impact on how Black communities receive care and can even impair how they care for their own communities. Public services that could address Black Canadians' needs include ensuring Black leaders are present in decision-making to ensure there's representation, or ensuring that Black healthcare providers are available to treat Black patients. Research from the University of Minnesota shows that patients tend to do better when matched with a physician that looks like them. This is in part because the physician will find their patient more credible and tend to pursue more aggressive forms of treatment, but also that the patient is more willing to trust their provider and follow their treatment. Another service could be to expand resources to understand differences in communication style or perceptions of risk. For example, research from the Charles R. Drew University of Medicine in Los Angeles, a historically Black medical school in the United States, found that while white people tend to get their information, their health-related information from physicians or the media, Black people prefer to get their health information from family members or community leaders. This is in no doubt due to historical mistreatment of Black people that has led to mistrust of the healthcare system rather than an essentialist biological reason.
Now, if I may,
So,
Yes.
your previous, let me ask my question, then you can ask yours, Justice Daguerre. Your previous example about wanting to have or needing to have, or better to have doctors or healthcare workers who look like the patient, that sort of highlights the problem here. I mean, getting race-based data to deal with a crisis now. It's not like that they're going to be able to graduate a whole host of Black doctors or nurses to respond to this crisis. Now, how is race-based data going to help with that? That's takes too long to have any impact on the crisis. The question is, how is the race-based data going to make a difference now for this crisis? What do you have to say about that?
Thank you, Justice. So race-based data can also...
Let me add this on, because I was going to ask a similar question, as well as the source of this data. It's not Canadian, and we're addressing a Canadian problem. So on top of what the Chief Justice has said, this is compounded by you're talking about the United States. What's the similarity? Do we not have our own statistics here so that you can refer to, because this is indeed, you're telling this court that this is our problem. So why don't we have our own statistics to rely on?
Yes, thank you, Justices. So if I'll give you an example. The City of Toronto has been collecting race-based data on the COVID-19 pandemic, including those who test positive and hospitalizations. While Black Torontonians make up 9% of the city's population, they make up 16% of COVID-19 positive cases. While white Torontonians make up 48% of the city's population, they make up 21% of COVID-19 positive cases. The situation gets worse with hospitalizations. Black Torontonians account for 24% of hospitalizations related to COVID-19, which is the highest of any ethno-racial identity surveyed by the City of Toronto. Now, just 2 days ago, the City of Toronto announced that it was investing $6.8 million for community agents to provide targeted outreach and support to Black Torontonians and neighborhoods with the highest percentage of Black Torontonians. This would increase culturally responsive health supports and mental health supports, food access provisions, and mobile and community-based testing. And now, Justice Slansky, to your question about how does the data help now? The data can help us in terms of your question about physicians in particular. The data can help us understand where, if Black Canadians are accounting for greater numbers of hospitalizations, will tell us where to send certain doctors and where to send certain healthcare providers in order to ensure those patients are getting the proper treatment they need.
Mm.
Now, Justices, yes? Oh. Now,
so
Justices.
Proceed, please. Proceed, thank you.
Okay, thank you, Justice Daguerre. Now, COVID-19 can be fatal. And for those who survive, illness and pain associated with COVID-19 can last for months. Canadian jurisprudence confirms that state actions that increase risks of death or physical or mental harm engage the rights to life and security of the person. Supreme Court affirmed this in Carter with the right to medical assistance in dying, Bedford with the right to sex work, and PHS community services in relation to safe injection sites. By not collecting race-based data, the minister increases the risk of death or physical or mental harm by not issuing public health measures or services that can address COVID-19's impact on Black Canadians. And my friends will argue that it's COVID-19 that threatens life and security of the person, not the minister. Minister will argue that there is no sufficient causal connection because there is no connection between collecting data and the harmful effects of the virus. But we say there is a sufficient causal connection. The Supreme Court held in Bedford that there is a sufficient causal connection when laws or actions increase vulnerability or deprive means of protection. While it was decided before Bedford, there was similar reasoning in PHS community services. Here, there was a sufficient causal connection when the minister's decision prevented administering what the court found to be life-saving medical treatment through a safe injection site. Mr. Williams is in a similar situation. The minister's decision not to collect race-based data prevents her from administering potentially life-saving resources based on COVID-19's impact on Black Canadians. Daily activities are inherently risky in the midst of COVID-19's rapid community spread. This is especially true for those who work on the front lines and in long-term care homes, of which Black Canadians are disproportionately working. But in Bedford and PHS, even though the acts of sex work and drug use respectively were inherently risky, that did not absolve the government of their role in increasing the risk of harm. The minister's inaction here increases the risks associated with Black Canadians' daily lives because risks can be mitigated through resource allocation and public services. In healthcare, data supports allocating resources and the development of the most effective policies or strategies. And further, without race-based data, the minister cannot remain accountable. Without the data, the minister has no baseline to track the current effects of COVID-19 on Black Canadians or track whether conditions are improving or getting worse.
Okay,
this makes it.
If
yes.
I may, accountability isn't the issue in this case, though, is it? This is about whether the failure to collect the race-based data is a charter violation or not. Not about accountability. That's some issue that may come up, later down the road in lawsuits or whatever. But isn't that the issue here? Whether there's a charter violation?
Well, there is, as our friends point out, there has been historical misuse of data when it's collected based on race. By holding a minister accountable and making this data available, those who work with the community and members of the Black community will be able to track the government's use of this data and hold the government to account for its actions and for its programming based on the data it collects. Is that helpful, Justice?
Go ahead.
Thank you. In short, without race-based data, the minister's picture of the situation remains incomplete, and so her response will remain incomplete. As a result, the minister increases the vulnerability of Black Canadians and deprives them of a proper means of protection. There's therefore a sufficient causal connection between the minister's failure and the increased risks to life and security of the person associated with COVID-19. And finally, we say that the minister's decision is not in accordance with the principles of fundamental justice because it is arbitrary. An arbitrary law is one that has no link between its purpose and the negative impact on a Section 7 right. Under subsection 4.2 of the Department of Health Act, the minister has jurisdiction to promote and preserve Canadians' health. This includes the protection of Canadians against risks to health and investigation and research into public health. In response to COVID-19, the government's objective has been to minimize the health, economic, and social impacts of the pandemic. The government states that its response is based on evidence-informed decision-making. The minister has not properly exercised her discretion in a manner that protects Black Canadians through evidence-based decision-making in response to COVID-19. There is no link between not collecting race-based data and an effective evidence-based COVID-19 response. Data informs policy response. And to minimize the spread, the government needs to know what's happening to communities across the country. To not collect this data is therefore arbitrary.
But who says how much data is needed? I mean, so you're saying you need race-based data. Well, you may need certain other kind of data and some other data. At some point, there has to be some reliance upon or deference to the governmental choices, unless those specific choices violate the charter. So there has to be a specific obligation here to collect race-based data. So again, where do you draw the line? as to how much data? You saying it has to be evidence-based, fact-based. Where do you draw the line?
Yes, Justice. Sorry, you cut out a little bit. So can I clarify, your question is how much data is needed and at what point do you draw the line?
Essentially, yes.
Okay. Yes, so we are asking the government to collect race-based data because race is one of the biggest indicators of health disparities based on the data that we do have. Some data has been collected through local initiatives, but these local initiatives tend to be difficult to sustain and can be different across regions where they're collected. By getting the federal government to collect this data, we get a nationwide picture of the situation. I will now turn to our Section 1 argument. The infringements on Section 7 and 15 cannot be saved under Section 1. The government is generally owed deference under Section 1, but this deference is not absolute. Section 1 is rarely satisfied when there's a violation of Section 15, and it's unlikely that due to the nature of Section 7 rights, a violation can be justified when it is not in accordance with the principles of fundamental justice. Now, Section 1 saves a charter right when there is a pressing and substantial purpose with a rational connection to the action that does not minimally impair the charter right, and the salutary benefits outweigh the negative effects. We say that first, there is no rational connection between the objective to implement evidence-based public health measures and the failure to collect race-based data, because excluding race-based data limits the minister's ability to make meaningful decisions that prevent the spread of COVID-19 among Black Canadians. Further, the absence of race-based data is not minimally impairing because the minister can collect race-based data when it identifies those who test positive, are admitted to the hospital, or unfortunately die. And further, the negative impacts on Black Canadians' health and lives outweigh the benefits to the public good. The negative impacts are severe. They disrupt individuals' lives, such as Mr. Williams, and families and communities grieve as a result. Entire portions of the population feel unprotected or less worthy of or deserving of government assistance. Black Canadians will continue to feel ignored and as if their lived experience does not matter despite the realities that they're facing. Now, in my remaining minutes, I will turn to our final theoretical argument on the Charter's guarantee of positive rights. Justices, the Supreme Court has not closed the door on recognizing the Charter's guarantee of positive obligations. In Gosselin, Chief Justice McLaughlin stated that the Charter may recognize such rights one day, and we say that that time is now. This court must recognize Canada's obligations to protect its citizens as guaranteed by the Charter. COVID-19 has severely disrupted the entire world. Hundreds of thousands of Canadians have been infected with COVID-19 and over 20,000 have lost their lives. Canadians face a previously unimaginable economic crisis that makes existing health and economic disparities impossible to ignore. It is under such circumstances that Canadians cannot survive but for the intervention of their government. And it is under these conditions that Canadians are warranted protection from their Charter. And under these conditions, when the government takes no action to determine the extent to which one segment of society suffers, that the court must breathe life into the Charter. This is supported through a critical race theory lens, because the Charter's negative rights approach perpetuates structural inequalities because it reflects a system that already disadvantages Black Canadians. The structural racism is tacitly accepted when the government takes no action to remedy the situation. Today, this court has the opportunity to address the structural racism that the minister herself advocates should be addressed. We are asking this court to reinstate the decision of the Court of Appeal that the government's failure to collect race-based data infringes Section 7 and 15 of the Charter cannot be saved under Section 1. That begins with recognizing the Charter's positive obligations guaranteed by Section 7 and 15. That time is now. And Justices, if you have no further questions, I will end the appellant's arguments here.
Any questions? I have none.
No further questions. Thank you, Counsel.
Thank you,
Respondent?
Justices.
Thank you, Justices. One moment, please. Good morning, Justices. My name is Teresa James, and my co-counsel, Olivia Huen, and I are representing the respondent in today's appeal. I'll begin by providing some brief context to the current case. COVID-19 has so far already claimed the lives of over 20,000 Canadians, and almost a year in, the pandemic is very much still an ongoing emergency. In response to this, to give you a sense of the scope of the federal government's response to the pandemic, the federal deficit is expected to reach over $1 trillion, which represents or reflects rather the unprecedented and extraordinary level of need from Canadians and demand and pressure on public resources. A lot of this investment has gone towards efforts and work by the Minister of Health to support direct and urgently time-sensitive measures to directly respond to the spread of the virus, from urgent prevention measures to testing and treatment and vaccines. Now, within this context, the appellant is seeking to impose a further responsibility on the Minister of Health, which is the positive obligation to engage in race-based disaggregated data collection. Specifically, the appellant, Mr. Williams, claims that his rights under the Charter have been, as a Black man, have been violated by the Minister's decision not to collect such data. Our position is that this appeal should be dismissed. In support of our position today, we have 4 arguments grounded in legal doctrine, as well as 4 grounded in critical race theory, or CRT. I will begin by discussing 2 of our doctrinal submissions and 2 of our CRT submissions, and then my co-counsel will continue with our remaining 4 arguments. I'll begin today with our first doctrinal argument, which is that the absence of race-based data does not infringe Section 7 of the Charter. And we're not following the exact order in our factum, but this is starting at paragraph 14 of our factum. So regarding the Section 7 claim, we note that Canada v. Bedford has established that a sufficient causal connection between the alleged harm and the government law or government action is required to find a violation under Section 7. And the claimant bears the burden of showing this causal connection. While obviously contracting COVID-19 is extremely harmful poses extreme risks to one's life and health, the appellant has failed to show that there is a direct causal link between this specific type of data collection they are seeking and this real harm. We note that as the appellant has said, the minister can't completely address and solve systemic racism in our entire society during the course of this pandemic in an urgent fashion. So in this sense, we note that any types of longer term policy initiatives and changes that might result from data collection and policy implementation would take likely years or more likely decades, given the way that health outcomes take a long time to change. And we would submit that any improved outcomes over this longer term period are far too remote from the mere act of race-based disaggregated data collection to constitute a direct causal connection. This is in particular because of all the many steps required to not only collect data properly and implement a proper categorization and database system, but also to analyze that data and translate it into meaningful policy. Now, secondly, and more importantly, we submit that the specific type of data sought by the appellant is not the kind of data that would be useful for these types of longer term policy changes. So we note that the appellant mentioned that they would support like an intersectional approach to this type of data collection, noting that this is an important approach to understanding the real racial health disparities at play here. But we emphasize, as the appellant have acknowledged, that the real data that would be useful for resolving systemic racial health disparities is data about the social determinants of health. So things like housing issues, income levels, and education and work environments. All of these things are factors that contribute to increasing the risk of Black Canadians, as well as other racialized Canadians, to this increased risk that they face related to COVID-19 and other health risks. Meanwhile,
Councillor, I want to ask the question on the last point that you put forward, that you know that am I understanding you correctly, that the data collected about the housing situation of Black people, where they live, their income base, it's all linked to their socioeconomic status or their as a Black person. Is that what you're saying?
Yes, essentially, a part of our argument rests on the understanding that the way that racism operates in Canada, specifically towards Black Canadians, is that we have this socially constructed systems that put Black Canadians in places and positions where they are at a much greater risk of contracting COVID-19.
Yeah, so you've already got that data, and you're challenging the appellant position about the intersection of that, and saying that since you already know that is the race that and systemic discrimination that caused them to be there, how much bigger a step you need to where you want to get, or where the appellant asking you to go? How much bigger a step you have to take when you have all that fundamental information? You just told me that the government knows that it's because of their systemic discrimination and because they're Black. So how much further does the government need to go to meet what the appellants are asking? Could you help me on that?
Yes, I'm in response to that question, Justice. I'm not sure exactly how much further the appellants would like the minister to go on this issue, but I would.
No, but I'm asking the minister, how far does it have to go? Having acknowledged that one's race is a fundamental, or if not the most significant reason why they are like low-income jobs, living in these crowded houses, etc., etc. You have that fundamental data already, you're telling me. So I'm just asking you how much further the government has to go to say, okay, well, this is health. What's the difference?
So we submit that because the minister has this underlying data, that there are many policy actions and changes that can be implemented in response to this, and it's not more data collection that is needed. So while we absolutely would not claim that Canada's response is perfect in terms of it always targeting the risk of Black Canadians, we argue that there's enough data out there to be able to implement such policies. And I would point specifically as an example to a recent report by the federal government entitled From Risk to Resilience, an Equity Approach to COVID-19. Now, in this report, the government has explicitly recognized the socially constructed racial disparities that are at play in who is at risk for COVID-19. In particular, the government has recognized the overrepresentation of racialized Canadians in higher risk environments related to workplaces and housing. Specific examples include their higher presence in like as staff in nursing homes or workers in meat processing facilities where outbreaks have been very severe. So what we are submitting here, Justice, is that we have this underlying data about the racialization of health risks, and the Canadian government can and should operate based on this assumption that there's enough data to infer that Black Canadians are at a higher risk. Now, if this appeal or this claim from the appellant was about a different allocation of resources to target a specific Black community in response to this data, this might be a different argument we're having, but our argument is based on the fact that we don't need to continue collecting specific race-based disaggregated data to implement the policy changes that might be meaningful. And I would also highlight as another example, this is not specific to the risk that Black Canadians face, but the federal government has recognized that Indigenous communities are specifically at risk and has prioritized vaccines for some remote Indigenous communities in Canada. So that in this sense, we would suggest that the government's response to the pandemic is not necessarily racially neutral. It might not be perfect and there might be rooms for improvement, but we submit that it can have a racially it can have a non-colorblind approach to policy without engaging in this additional disaggregated data collection.
If I may, if I understand you correctly, you're saying you don't need race-based data because you have other indicia that sometimes relate to race, such as housing, financial status, et cetera, and therefore you have sort of a substitute for or some other way of assessing race-based issues through these other indicators. Do I have that right?
Yes, that's correct, Justice.
But you're not saying, are you, that there isn't systemic racism aside from these indicators, are you? I mean, there may be actual, anti-Black racism that rears its head through indicators other than housing, economic status, et cetera, et cetera. You're not rejecting that, are you?
No, Justice, we absolutely do not reject that argument. So in response to that, I would just point out that our submissions recognize very much that even though these social determinants of health are really key in understanding the actual real causes of why Black Canadians are at higher risk, what we submit is that with regards to understanding race in and of itself as an isolated sort of indicator that we need to be looking at, we would point to the risks of taking a sort of single axis approach to race in medicine, which has a high risk of essentializing race as this kind of biological or genetic category that is extremely problematic. And within our CRT perspective on this issue, we note that several critical race theorists have pointed out that using race in itself as an indicator of potential health risks and outcomes has found to be very problematic and in healthcare services, because it has this risk of attributing health disparities to supposed biological differences between persons of different racial backgrounds, which perpetuates really harmful legacies in the history of medicine. So in particular, authors such as Dorothy Roberts and Judith B. Kaplan have noted that when we take this kind of approach to simply looking at, what race is a person and what, medical condition they might be at higher risk of contracting as a result, there is this risk that practitioners will take race as itself as this, understanding it as the cause of illness and not assess the appropriate factors that they should be looking at when assessing patients. So in particular, in medical institutions where whiteness is often treated as the default, you have the situation where white patients are likely to have their appropriate factors like their symptoms or their family history considered. Meanwhile, it's been recorded that Black patients are more likely to be misdiagnosed or have inaccurate and inappropriate treatment in response to their own situations.
But is that a problem of race or a problem of ignorance?
It's definitely...
Is it race or ignorance? For example, we know that sickle cell anemia is, a lot of Black people have it. And for that reason, people like to believe, and probably this is to your point or not, that somebody comes in who is probably Egyptian or from Europe with the same symptoms, but they never diagnosed sickle cell anemia because it's limited to race. And was that not the subtle message that CRT advocates are saying? And they're not saying don't look at race at all. They're saying don't make it the focus of everything you do, but it's important to include it. Is that not what it is? As opposed to totally don't take it into consideration and that it must be contextual?
Absolutely. I thank you, Justice, for explaining it in that way. I understand that is the view. We don't advocate for completely ignoring race at all. We believe that would be a very problematic approach, but we do say that it's not the one and only thing we should look at because of these harmful risks and effects that can result, that can happen.
But nobody's saying that it's the one and only, though. I don't understand anyone to say that it's the one and only. I think that the argument has always been the intersectionality of these things and how dominant race is, whether you take it into consideration or not. And I think this is exactly what they're saying, that you don't focus on that alone or you could be misguided. And then I want to add to this that you used a term the other day about a colorblind, a few paragraphs back. You want to take a colorblind approach. Could you expand on that? Because I really don't know what it means in this context.
For sure. Just to clarify, I might have misspoken. I meant to say, Justice, that we do not want to take a colorblind approach to this issue. A colorblind approach would be saying that just essentially ignoring the real problem here, that there are systemic inequalities, and treating everyone equally and avoiding any policies that might target groups that are at higher risk, which is absolutely not what we think, what we submit it would be the right response. And we argue this is not entirely what the government is doing.
But the government wants to have its cake and eat it too. No? That's my perception from the government's presentation.
I'm not sure I understand in what sense.
Well, the government is arguing that it has all these stats that are race-based and it's all helpful. And then on the other hand, it's saying, well, we don't need it because we have other things already. And I'm not totally clear on how it's using this information to further its position.
Okay, and thank you, Justice. Essentially, what we are trying to say is we have enough existing information out there to recognize and appreciate the racialization of risk for health issues. And taking that knowledge, we should, rather than investing more resources, not just financial resources, but also human resources and time resources during an emergency, in collecting more data about something that we kind of already understand it exists as a problem, we should invest these limited resources in more urgent and directly responsive measures. And on that point, I would highlight the fact that this goes to the nature of the policy nature of this type of decision. So if I move into my next
because the government, no one knows anything about COVID as far as COVID-19. It's an international pandemic that everyone is still struggling to understand. So we can't say you got this data and therefore this data is good enough to address an unknown, the unknown, because we don't know much about COVID. I mean, the scientists will tell you they don't even know if the vaccine is going to work and how impactful it is on the variant, et cetera, et cetera. So this is what I'm saying, that you said that it's pandemic, it's new, it's international. So it's unprecedented. So how do you know that your previous data that you have is applicable to this current unknown?
Thank you, Justice. We understand and appreciate the fact that there are so many unknowns still in this pandemic. However, we think it would be disingenuous on the part of the government to claim that because we don't know everything, we can't accept that there is a problem with racism and how Black Canadians are disproportionately affected, especially when communities are telling us that this is the case. So we submit that the best approach is to operate on the assumption that the safest way to go forward is understand that this risk does exist for Black Canadians, and rather than investing resources to collect more data about that, we propose investing resources in direct measures that are more responsive to the actual risks that Black Canadians face, including treating them in hospitals and providing better testing. And that could include, better targeting of testing in specific communities where there are individuals at greater risk. And if I may move to our next doctrinal argument, this relates to how much of the policy nature of this type of decision, because as we have just, as was found by Justice Brown in the Supreme Court decision currently on appeal. This is fundamentally a political decision by the minister about how to provide public health care. And while we understand that given these other complexities about collecting race-based data and how it can be problematic, we suggest that this court appreciate that there are a lot of risks in not just in choosing to collect the data or not, and that the government and policymakers have weighed these risks, not only against the other potentially more effective uses of the public resources, but also against potential harms to the very communities these actions are intended to benefit. And we submit that the courts are not necessarily in a better place than political decision makers who have access to the kind of institutional expertise about statistics and have access to community consultation mechanisms to really appreciate the risks and decision making. Furthermore, we submit that this charter cannot create the type of positive duty for the state to collect this specific type of disaggregated race-based data. This is because even though the door has technically been left open to positive obligations under the charter in Gosselin v. Quebec, that decision occurred almost 20 years ago now. And every single time, in particular, a Section 7 based charter claim has come before court in Canada, the courts have consistently found that it is still not yet, although the door has remained open for positive obligations, none of those courts have had a case that has allowed us to walk through that door. And
what do you mean by positive obligation here? I mean, there are a series of cases in which the Supreme Court has said that there can be positive obligations where the state is in some way engaged. So for instance, in JG, the state is engaged in a state proceeding, such as a criminal prosecution, or in that case, child protection proceedings. And because of that state engagement, there is created a constitutional obligation for front counsel. There's a series of cases such as Shauli, Nova Scotia Pharmacies, Farinacci, in which where the government is otherwise as legislated in the area or stepped into the area, that then there is a constitutional obligation. Same with Breen, where they pass human rights legislation, it has to be done in a constitutional manner. Does that not apply here, in particular through the Shauli example, where the government has created universal health care, that then there is a constitutional obligation to make sure that it's done in accordance with constitutional principles? Is that not already clear in the jurisprudence?
Thank you, Justice. Absolutely. It is clear in the jurisprudence.
And let me add to this, and if it's not clear, we are now facing a global pandemic, like unprecedented. And does that not give the court pause to actually look at this and say, this is unprecedented? Yeah, this could be the living tree of the Constitution, as the court said in the person's case. This could be the opportunity to allow it to expand.
Thank you, Justice. Yes, of course, this is an unprecedented context and a potentially opportunity for change, including in regards to our jurisprudence on these issues. However, we submit that the most unprecedented part of this situation is how overwhelmed our public healthcare resources are at this time, and that is why all of some of the most extreme government restrictions have been imposed on our across jurisdictions in this country, is to alleviate the pressure on these resources. And going towards Justice Slensky's question about whether that other jurisprudence about applies in this case, absolutely, the jurisprudence confirms that once a state provides some sort of benefit or legislative scheme, it needs to do so on an equal basis. However, in this case, unlike in cases such as Brienne v. Alberta, there is no existing legislative regime in place, at least none that the appellant has raised as actually being a cause of a source of inequality. And as my co-counsel will also discuss, there is no existing benefit with regards to data collection that is being denied to one group but provided to another, which would distinguish it from cases like Eldridge, where there was the access to healthcare service in and of itself was effectively denied to one group of claimants based on a protected ground. In this sense, we would also submit that as a last point that the any order to have the minister engage in this type of disaggregated data collection would infringe on the provincial jurisdiction over healthcare. It is settled law that under Section 92 of the Constitution Act 1867, provinces have exclusive jurisdiction over hospitals, and the jurisprudence, such as cases like R.V. Morgentaler, confirm that that other parts of Section 92 include exclusive jurisdiction over healthcare matters generally. This also includes matters of cost and efficiency and management of hospitals. In this context, we submit that if any charter obligation could possibly be found in this appeal, the obligation would need to be owed by the provincial government and not the federal government. And now my co-counsel Olivia will continue with our remaining arguments. Thank you.
Thank you. Today I'm going to present our last two doctrinal arguments. First, that the minister's decision does not infringe Section 15 of the Charter. And second, even if the minister's decision infringed Section 15 or Section 7 of the Charter, it would still be saved under Section 1. I'm then going to present our last two CRT arguments. First, that the approach suggested by the appellants is not an intersectional approach to addressing racial disparity and health disparities. And secondly, that race disaggregated data collection can exacerbate over-policing. I'm going to begin with our third doctrinal argument, that the minister's decision does not infringe Section 15 of the Charter. The Section 15 test was recently reiterated in paragraph 27 of Fraser versus Canada. The first prong of the test is that there must be a state law or action that creates a distinction based on enumerated or analogous grounds. And this argument begins at paragraph 20 of our factum. The second prong of the test is that the state law or action must deny a benefit or impose a burden in a way that reinforces, perpetuates, or exacerbates disadvantage. And the case at bar does not meet the Section 15 test for two reasons. First, because there's no existing benefit provided by the federal government. And second, because the appellant has not demonstrated a sufficient causal connection between the minister's decision not to collect race disaggregated data and the disproportionate impacts that Black people face in terms of COVID-19 risk. First, there's no existing benefit. So the federal government does not currently require disaggregated data collection based on other protected grounds, such as sexual orientation or religion. There's no benefit of data collection that is being offered to other groups, but being denied to racialized people.
Excuse me, with respect to benefit though, I mean, doesn't it depend on how you define it? If you define it as data collection and there is no data collection, that there's no denial of a benefit. If you define it as healthcare, effective and adequate healthcare, that is certainly a benefit. And if the data is necessary, and I'm not saying it is, but if the data is necessary to have effective and fair healthcare, then isn't that a denial of that benefit or an adverse impact on that benefit by not collecting the data that's necessary?
Yes, we believe that if the data were absolutely and indisputably necessary for the provision of effective healthcare, there could be considered to be a disparate impact. However, while the appellants have characterized the minister's decision as simply a decision to do nothing, we believe that the court should view the minister's decision in light of its broader COVID-19 policy, especially in the context of the unique resource strain that COVID-19 has put on governments. So the minister's decision not to collect race-based data was because the federal government decided instead, having sufficient information on how social determinants affect racialized people, to instead put those resources towards addressing those social determinants directly. So for example, addressing the social determinant of income through income supplements such as the CERB, and addressing the social determinant of housing through things like trying to expand affordable housing during the pandemic and providing eviction stays. As well, while we acknowledge the presence of systemic racism, there are also other groups who are particularly vulnerable to COVID-19 due to the nature of the virus. For example, people in long-term care homes. So the minister's decision in this case was meant to address as wide a range of vulnerable groups as possible. And that's why, for example, things such as the CERB are not means tested to the extent that is possible. So for example, one doesn't have to prove or declare one's race in order to access these benefits. When the court addressed a Section 15 case in Tanujaya versus Canada, it emphasized that there's no general right that everyone is to be free of unequal or different treatment, and that a breach is discriminatory only insofar as it does not provide equal protection or equal benefit of the law. And similarly, in Ottawa versus British Columbia, the Supreme Court of Canada held that discrimination under Section 15 required a prior showing that there is a benefit provided by law, and that there can be no administrative duty to distribute non-existent benefits equally. We can distinguish this case from Eldridge versus BC that the appellants cite, because in contrast to providing interpreters, data collection is not in and of itself an accommodation, and the mere fact of data collection does not inherently change how service is provided. Given the emergency context, data collection may actually impede access by directing resources away from frontline measures. As my co-counsel mentioned, it may also have adverse effects on racialized communities if the data is abused by state actors, or if enforcing the norm of race-based medicine leads to discrimination on the part of medical practitioners. We submit that it's dangerous to set the precedent that the government must collect race-based data in order to meet its Section 15 obligations, because this means that future governments will be pressured to conduct race-based data collection even if they don't have the resources or the tools to conduct it properly. And also that future governments are likely to overlook or underplay the burden and disadvantages that the process of data collection itself can impose on marginalized communities, because they will be focused on avoiding Section 15 liability. As well, there's no clear comparator group for the appellant Section 15 argument. It's unclear which group is benefiting, because even if race-based data collection was meant to be an ameliorative program, we submit that it would still be under-inclusive. So as we explore in our CRT arguments, race is fluid and a subjective experience, and identities are intersectional. And this complexity of identity that compounds many people's oppressions on multiple axes is unlikely to be captured by state data collection, which instead risks essentializing race.
So you're saying because you could do more and you're not, then you should do nothing.
Justice Lansky, what we're saying is that we support a bottom-up approach of directly attacking social determinants that people face because they are marginalized on multiple axes. So for example, housing insecurity disproportionately affect Black Canadians, but we believe it likely also disproportionately affects, for example, disabled Canadians and Canadians of lower socioeconomic status. So rather than focusing on race as the primary lens or as a singular lens for addressing these issues and these causes of health disparity, we'd rather address the social determinants themselves, because we believe that can capture the experiences of people who are marginalized on multiple axes. As well, the appellants have not proved a sufficient causal connection for their Section 15 claim, because they have not explained how data collection itself is necessarily going to lead to improved policy. And as an example, they use data from the US that has been collected about Black Americans and disproportionate COVID-19 risk. However, we believe that the example of the United States is actually an example of a case where race disaggregated data collection has failed to lead to improved public health outcomes for anyone. Because even though the United States does collect race disaggregated data, it's also faced some of the worst COVID transmission rates and COVID death rates of any developed country in the world.
But has the US experience been responsive to issues of race in how they deliver or for that matter, don't deliver their health care.
No, we believe that the United States poor COVID outcomes are related to the fact that this data collection has not translated into effective policy. I'm now going to present our next doctrinal argument that even if Section 7 or Section 15 of the Charter was infringed, the minister's decision to not to collect race disaggregated data would be saved under Section 1 of the Charter. And this begins at paragraph 28 of our factum. Under the RV Oaks framework, justification for Section 1 requires 3 elements. First, that the limit on charter rights be prescribed by law. Second, that there be a pressing and substantial legislative objective. Third, that the means be proportional to that objective. As well, we note that the Supreme Court of Canada has held that courts owe greater deference to government decisions in cases where the legislative branch and its officials have institutional competence. As well, they owe greater deference to government decisions when the charter limit arises from complex policy decisions, which engage competing interests, social science evidence, resource demands, and the protection of vulnerable groups. We would note that the case at bar engages all of these criteria. Moving to the first prong of the test, pressing and substantial objective. We believe that addressing the social determinants of health is a pressing and substantial objective, that it's clearly linked to protecting the health of Canadians. We would also recognize, as my co-counsel said, that the COVID-19 is unprecedented, largely in part because of the strain that it's put on all governments and all economies, which have limited the range of actions they have taken and have unfortunately forced them to have to choose between different possible effective routes of action. Given the rapid spread and high death rates that many provinces and many communities are facing, the decision to focus the federal government's resources on direct measures contributes more to the protection of health than extensive data collection would at this stage. Moving to the next prong of the test, that the means must be proportional to the objective. Firstly, there's a rational connection between the government decision and improved public health outcomes. So there is a rational connection between allocating resources towards testing, contact tracing, and treatment, and improved public health outcomes, because all of these things directly affect people's ability to know when they should self-isolate, for example, or to receive effective treatment for the virus. Next, even if there is an impairment of rights, this impairment would be minimal. The appellants have not sufficiently proven, as we've mentioned before, a causal connection between disaggregated race-based data collection itself and actually reducing racialized health disparities. Therefore, because there's not a strong connection, any connection that does exist is likely to be distant and remote, and so the impairment would be minimal in this case. As well, the appellants claim in their factum that data collection would have minimal cost or intrusiveness to the government. However, what we have to consider is the strain it would put on the government's ability to respond to immediate public health challenges and to continue funding those direct measures. If they are forced to bear the cost of creating these data collection tools, creating and maintaining databases to store and organize information, investing in cybersecurity to protect that information, and the human resources cost of collecting, organizing, and analyzing the information, as well as coordinating not only between different provinces, but also between different hospitals and different healthcare providers.
If I can ask you to go back for a moment, you're discussing Section 1, and several times you said, well, the appellant hasn't provided evidence of this or evidence of that, evidence of the effect of the lack of statistics, etc. But when because you're in Section 1, you're already at the point where, at least arguendo, you are saying there is a violation, and then the onus shifts to the government, both with respect to persuasion and evidence. So are you citing any evidence to say that it doesn't make any difference? Because again, conceptually, you're already having, in the Section 1 context, you already have a violation.
Yes. While we don't have any evidence to suggest that it would make no difference, because again, the COVID-19 pandemic is still at a relatively early stage, we do believe that logically, given the limited resources on the government, it does make more sense to invest those resources in directly addressing social determinants of health rather than spending them on data collection. And this is again for the reasons I mentioned that we've already identified, and we believe we actually agree with the appellants on this point, that the primary reasons that Black Canadians face health disparities are not for biological or physiological reasons. Rather, it's because, as the appellants mentioned in their factum, Black Canadians are more likely to work frontline jobs, are more likely to live in high density areas where it's harder to social distance and so on. And given that we already know those things, we believe that the best outcomes will be achieved if we focus the government's limited resources in these times on directly addressing those things. So providing aid to frontline workers, trying to improve housing conditions and so on, rather than on further data collection. We would also note that race-based data collection is tracking the race of individuals, but the approach that we propose is to attack the social determinants and the causes of systemic health disparities instead. I'm now going to move on to our third CRT argument, that race disaggregated data collection does not capture intersectional identities, which begins at paragraph 35 of our factum. So first of all, we submit that race-based data is only useful to governments and to communities and individuals if it is accurate. However, the tools to collect race-based data are often incredibly limited in the scope and complexity of information they can gather. And they often exclude or oversimplify certain identities, which can compromise the accuracy and consistency of the data. So for example, as Judith B. Kaplan notes, that tools like surveys often have a limited range of responses that again exclude certain identities. They also often conflate race, ethnicity, nationality, and ancestry, which compromises the consistency of the data collected. They often exclude biracial or multiracial identities. As well, the context in which data is collected can itself affect participants' responses. So how individuals choose to identify can be influenced by factors such as who's collecting the information, how information is collected, and how participants perceive the information will be used. So as a result, even if the state does collect racial data, the state-created racial categories involved in that data collection are unlikely to accurately reflect the racial identities of participants, which compromises the usefulness of this data. This is especially true in a medical context, because when data is collected when people enter the medical system, or oftentimes when they become deceased within the medical system, they're not in a place where they can advocate for themselves about and explain their racial identity, or even use tools like questionnaires. So often when people enter hospitals, especially due to COVID, they're often unconscious or too ill to fill out tools like surveys. Medical professionals may not feel like it's an appropriate time or that they have an adequate relationship with the patient to require them to use these racial identification tools. And at the point where data is collected when patients become deceased in hospitals, they're not able to self-identify. So assumptions are often made, for example, based on the appearance or race of relatives, or based solely on the patient's appearance. As well, we believe that the approach suggested by the appellants promotes a single access framework approach to collecting or to addressing health disparities. As we mentioned before, we want an intersectional approach that directly addresses social determinants that affect people who are marginalized along multiple axes. The COVID-19 pandemic is a seminal moment in Canada's public health strategy, and the order sought by the appellant will only entrench single access frameworks as the norm for anti-discrimination law during this crucial time, which limits the potential for intersectional approaches in the future. Finally, we believe that the abuse of race disaggregated data by state actors may contribute to the overpolicing of marginalized communities. So we recognize that anti-Black racism likely plays a part in health disparities, but it's unfortunately this anti-Black racism that also makes data collection itself burdensome and risky for Black individuals and Black communities.
Despite the presence of FIPA, Freedom of Information and Protection of Privacy, and the rigorous policies that are there in the collection of data, and a commission, an institution that you can complain to in that event, and the policy section that's set up how and when and why information can be gathered with the sole interest of protecting the privacy of individuals. Government has that, and you have such marked fear about government collecting the data and meeting its own privacy policies.
Yes.
This perniciousness that may flow from the gathering of the information with an institution that the government has and say that it is so efficacious, it gives me pause to embrace your argument.
Yes, those concerns are understandable. However, despite the government's best efforts and despite the government's desire to protect data, we see that the government and multiple independent institutions within the government are not always effective at doing so. So in paragraph, in paragraph 44 of our factum, we cite a situation where the Canadian Civil Liberties Association identified that Ontario Police had improperly accessed a COVID-19 database that they were not supposed to use. And they took information from that database for reasons that were unrelated to the public health purpose of the data collection. I believe my time is up now.
Had you finished your thought? You can finish your thought if you hadn't. If you have, that's fine.
Okay, I have a couple more lines.
Okay, go ahead.
I would suggest, Mr. Chief Justice, that we have engaged her perhaps more so than others, and she wants another extra 5 minutes.
5 minutes? I don't know about 5 minutes. Just finish your thought. I don't think she's been engaged any more than anyone else. Finish your thought and wrap it up then.
Thank you. So unfortunately, the reality is that part of recognizing the way that systemic racism operates is recognizing that institutions can unwittingly perpetuate it. And so, for example, that the government holding data does run the risk of that data being accessible, for example, to police, who might in turn use it for racially profiling Black individuals. We believe at this time, when we don't have the full resources and the full personnel to invest in things like cybersecurity for this database, it's not a good time to begin racist aggregated data collection. And for these reasons, we seek for the order, we seek to maintain the order from the Supreme Court of Canada. And we request that the appeal be dismissed without cost. And in the alternative, we request that the order for race-based data collection be suspended until the COVID-19 pandemic has ended.
I'm not sure I follow that last point. What's the point of suspending it until COVID ends if this is necessary for COVID? But again, we run out of time here, so I'll just make that point. And unless there are any other questions, Justice Daguerre, Justice Peters, you're muted. You're muted, Justice Peters. Looks like you're talking but muted. There you go.
Sorry, I missed what you just said, Chief Justice.
I was just saying that suspending the measure and the alternative suspending the measure until after COVID is ended, I'm not sure what the point of that is. The whole point is to do it while COVID is going on. But again, I just made the point and I'm not really going to pursue it since we don't have time. And I asked whether you or Justice Daguerre had any further questions.
No, Chief Justice.
Okay.
I have no further questions.
Okay, then we have reply.
Yes, Justices, I would like to make a brief reply. Our friends have made 3 points that I would like to address today. First, our friends contend that they have collected, or the minister rather, has collected enough data to protect Black Canadians through social determinants of health, such as income, housing, food insecurity, and otherwise. However, we're almost into a year within the pandemic, and nothing has been done for specifically Black Canadians. This data would hold the minister accountable to racial inequities. At least in other countries, such as the US and UK, race is acknowledged to be a reason for health disparities for racialized communities. This data would then prioritize affordable housing and also better legislative protections for essential workers, such as thriving rates or increased sick days. We believe that this data is necessary. And by not collecting race-based data, the minister is hiding behind a wall or a fence, which refers back to my original analogy. We want the minister to provide resources to the communities who need it the most. Secondly, our friends have also stated that there is a fear that data will not be, there's a fear that Black Canadians will fear data being collected. However, the minister can provide clarity on how data will be used, so patients will want to give their information. They can ensure that there are protective measures, so information is not used to surveil or police racialized communities. These are resources that the minister has within its reach. They can also work with racialized communities to ensure that these are happening, to ensure that data will remain confidential, and provide training to healthcare providers to ensure that there is a clear purpose and scope when conducting these surveys. And lastly,
if I may, I mean, education isn't always sufficient. I mean, in the United States, I saw some, again, news reports that for instance, the people in Tuskegee were still pretty reluctant to be vaccinated because of their distrust of government, because of what had happened in the past. So education has its limits, doesn't it?
Yes, I would agree with you, Justice, there, but I do believe that working with racialized communities like Tebu can better assist the government to ensure that they're collecting the right information and asking the correct questions. And to my last point, our friends have said that the social determinants can better capture intersectionality. However, the Canadian Institute of Health has proposed a standard which enables recognition of multiracial identities. This emphasizes the need to permit multiple responses to health inequities, so they can be reported using mixed categories. An example of this is which race category best describes you? Check all that apply. There are many different ways that we can encapsulate race and discuss all the different, for lack of better words, the Black experience. If you are disabled, if you are queer, there are so many different ways that we can capture this, and the government does have the resources. Because without it, the government cannot address what they cannot see. Thank you, Your Honor. That's all my submissions for today.
Well, thank you all. Do we have anything else that we need to address? Ms. Harris,